Everybody, it's Matt Scudero with the Credit Research Foundation. Thank you for joining us, and I think you're going to really enjoy this topic today. I am super excited to have George Angelique with Arent Fox, a friend of the foundation, with us today, and is going to be speaking in one of our micro-learning sessions on Subchapter 5 of the Bankruptcy Code. I know it's a topic that is impacting all credit professionals out there, and certainly one that is changing the landscape for how we operate. This is a micro-learning session. It is one of a three-part series that Arent Fox organization has shared with us. Obviously, it's Subchapter 5. We have rights of offset as number 2 and receivership as number 3. I know you're going to enjoy all three parts of this. George, I want to thank you for your support. I know you took out some considerable time for this session. I know you're also doing a longer session for us in our forum, our March forum, and you continue to provide all sorts of content to the discipline and to the foundation. And we are extremely appreciative that all that you do, as well as the foundation, the firm, and sharing that content with us. We want to say thank you for that and all that you do. I'm going to pass the baton. I know this is an important topic. You're going to share some information with us on it. And so I think the baton at this point is all yours, George.
Thanks so much, Matt. George Angelique of Arent Fox. It's a real pleasure to be here today. We're going to do Subchapter 5. We're going to try to do it in 5 minutes, but I'm going to aim to give you 5 key takeaways to remember about Subchapter 5. At the end of this program, if you stick with it, there's going to be a bonus topic on preferences and some of the new developments around preferences that Subchapter 5 and the recent case law and statutory adjustments have made this year. As Matt also indicated, we're going to have a longer session about Subchapter 5 where we're going to do a much deeper dive into Sub 5, how it operates, and things for you to look out for. So the traps for the unwary about Subchapter 5 are coming. We'll give you that in a few weeks. So what is Subchapter 5 and why are we talking about it so much? Well, it's a new process under Chapter 11 for small businesses. It's fundamentally a streamlined version of Chapter 11. We'll talk about what are some of those key topics that streamline this form bankruptcy, but it was signed into law in August of 2019. It went effective in February of 2020, and it came into law on the heels of the start of the global pandemic. And as a result, Congress, through the CARES Act, enacted some important adjustments to Subchapter 5. One of the key topics that were adjusted, we'll talk about in a moment, and that is the debt level for eligibility. What does Subchapter 5 do for small businesses? Well, there are certain benefits and burdens. One of the benefits of Subchapter 5 is that there is no official committee of unsecured creditors. There are no U.S. trustee fees. Subchapter 5, however, automatically appoints a Subchapter 5 trustee. There are no creditor plans. All Subchapter 5 reorganization plans are debtor driven. They call the shots. That's one of the benefits. However, the burdens are pretty significant. Next slide. Okay, eligibility. What is eligibility? Well, a key issue in eligibility is that you have to have total debts, non-contingent debts of less than $7.5 million. The debt cap was temporarily increased from about 2.7 million to 7.5 million under the CARES Act. And unless Congress extends the law past March 27th, the statute will snap back to a $2.7 million cap. We expect that Congress is going to pass new legislation. The Biden administration has indicated that they will sign into law the extension of Subchapter 5. So right now there are a variety of legislative efforts and lobbying efforts to keep Subchapter 5 at this level. So we expect that that will be the case, and we will see a continuation of this statutory cap at the $7.5 million level. And there has been some discussion that it could potentially be increased. Next slide. Duties of a Subchapter 5 debtor, benefits and burdens. One of the key things to think about here is that the debtor is held to a very strict timeline. Now, we've seen a lot of instances since the enactment of this statute where debtors, Subchapter 5 debtors, have requested for certain extensions of key milestones. One of the key milestones that the debtors must observe is that, for example, they must file timely bankruptcy schedules and statements unless the court grants an extension. And extensions cannot be more than 30 days after the petition date, absent extraordinary circumstances. It's one of the key hallmarks of Subchapter 5. It's designed to keep the debtor on a very tight timeline and on a tight leash. Why? You want to get the benefits of Subchapter 5 by getting through bankruptcy quickly to keep costs down. So next slide. So you can see there's a Subchapter 5 trustee. As I mentioned, a Subchapter 5 trustee is appointed in every case automatically. Subchapter 5 trustee plays a significant oversight role in Subchapter 5 cases. It ensures that the debtor is meeting certain reporting obligations, that it is providing information and disclosure in accordance with the statutory framework. And it's really designed to be there as a sounding board to ensure that creditors are being carefully that their rights are being carefully observed and respected. So Subchapter 5 trustee can, in certain limited circumstances, retain professionals, but for the most part, there's been very few instances where Subchapter 5 trustees have hired their own law firms or hired counsel. So they're really involved in the case early on, monitoring the debtor's finances, ensuring that there is compliance with the statute, making sure there are key disclosures. And really their goal is to make sure that in that Subchapter 5 plan, that there is transparency about the future ability of the company to do business. So next slide. One of the things that, one of the burdens on the debtor is that it has certain key milestones to observe. The Sub 5 report is due 15 days prior to the Sub 5 conference. So keep in mind, as you're internally monitoring a Chapter 11 case, and you see that it's a Sub 5 case, be aware that the debtor is going to be issuing a report within 14 days. Then there's going to be another Sub 5 conference about 60 days later after the case files, and then a Sub 5 plan filed within 90 days. This timeline is very important. It's critical that you monitor it because certain key disclosures will be made each step of the way. So, and the debtor, by the way, is unable to extend these deadlines absent cause, and they're held accountable. Courts have been willing in certain instances to extend those deadlines, but the burden is rather high. Next slide. Sub 5 plans and confirmation. There is no separate disclosure statement required in Sub 5. Very important. Unlike your regular Chapter 11 plan, which is your plan of reorganization, plus that very important disclosure statement that helps you understand how the plan works, you don't have that in a Sub 5. It's strictly the plan. And you're in the position of having to make a voting decision on that plan. One of the key things to think about is administrative claims. And we'll talk about that at the end, which is coming up in a minute. But you've got to be aware that admin claims can get stretched out in Sub 5, and your plan is going to tell you if it is. Next slide. Takeaway number 5, what are some of the best practices for trade creditors? Well, we'll talk about this in more depth during our longer presentation in a couple of weeks, but some key takeaways for you to keep in mind. There are things that you need to be on the lookout for. Be vigilant. If it's a Subchapter 5 case when it files, keep in mind that the debtor, through the plan, can potentially stretch out your admin claim payment over a 3 to 5 year period. We're accustomed to receiving payment in full of admin claims on the effective date of a Chapter 11 plan, not entirely the same in a Subchapter 5 plan. Rather, what can end up happening is you can have a stretch out payment plan of up to 5 years for your admin claim. We're not even talking about your general unsecured claim, your admin claim. So some of the things you need to be thinking about when you get that plan: should you vote in favor of it or against it? You have two kinds of plans in Subchapter 5, those that are consensual and those that are non-consensual, meaning creditors have voted against the plan. So even if everybody votes against this plan, it could nonetheless be confirmed as a non-consensual plan. What happens when you have a non-consensual plan? Well, your Subchapter 5 trustee will remain in place in a position to monitor the debtor's performance. And there'll be an extensive monitoring process that can go on for several years, where the Subchapter 5 trustee could even act as the distribution agent for your claim. So there are benefits to Subchapter 5. There are burdens to Subchapter 5. One of those is that if a debtor ends up with a non-consensual plan, you're going to have considerable oversight from the Subchapter 5 trustee for the duration of the plan life. So we'll have more about some of the best practices for trade creditors in the next couple of weeks when we do our lengthier program. Last slide. Last slide. In the weeks ahead, we're going to have more about Subchapter 5 by my colleagues, Justin Kesselman and Doug Flau. And as promised, the final takeaway here: preference. As everyone knows, the avoidance provisions of the Bankruptcy Code give debtors the ability to recover preferential transfers made in the 90 days preceding bankruptcy. The defense that trade creditors rely on is the ordinary course of business defense. And over the last year, there's been a lot of questions around what is ordinary course of business in light of the pandemic and all of the uncertainty that's emerged over the last 12 to 14 months. So to incentivize really landlords and vendors to enter into forbearance agreements with their tenants and debtors, the Act exempts from preference avoidance certain late vendor payments made in accordance with those forbearance agreements that debtors execute with their vendors, suppliers on or after March 13th, 2020, on account of contracts that relate to agreements that were entered into prior to March 13, 2020. And really, this is intended to preclude creditors from taking extraordinary collections actions against insolvent debtors. But the payments made by the debtors in the ordinary course of business are exempt from preference avoidance. The Act is designed to help exempt payments made pursuant to certain forbearance agreements, and by doing that, exempts them from preference recovery. So what the Act doesn't do, however, it doesn't exempt late charges and interest payments if they are more than a debtor would have incurred if the debtor had made all of its payments in a timely manner. What's really challenging about this change in the law is that it does have a sunset provision. There is some vagaries in the statute. We haven't really seen any instances yet of it being addressed by any courts, but there will be plenty of litigation that comes out of this topic in the months and years ahead. So very important thing to keep an eye on and explore whether you can enter into a forbearance agreement and in reliance on this statute. So more about this in the weeks ahead, and appreciate everyone's attention. And thank you, Matt, for having us today.
George, no, thank you. A tremendous amount of information in a very short period of time. Subchapter 5 impacting so many folks. Really appreciate the bonus piece here on preference development, and we will stay tuned and look for support and education on that as well. Again, this is the a session in a three-part series, right? So it's Sub 5, it was right of offset, and it's leadership. We are extremely appreciative of all that you do, George, as well as your colleagues there at Arent Fox. And as George mentioned, stay tuned for the in-depth version of Subchapter 5 at our March 2021 forum, where we'll have Justin Kesselman, Doug Flout, and George Angelique talking about this in depth. Such an important topic for so many folks. So we hope you enjoyed it. If you have any questions, I know you can reach out to George and his firm. or reach out to CRF. We'd be more than happy to put you in contact with them as well. We say thank you and look forward to seeing you again real soon. Take care, folks.
Thank you.